again, my name is Tara Magitz. I'm an attorney with the law offices of Drinkwater and Goldstein. This is one of a continuing series of videos on various topics within the law. Today we're going to be talking about an interesting topic, one that does not seem to have a significant amount of cases, at least in New Jersey anyway, dealing with the situation, although there is one from 1988 that we're going to discuss in some detail in a little bit. As always, the disclaimer is that my law firm practices in the state of New Jersey. All of the advice and information, unless I indicate that it's for a different state, is designed and intended only to be relevant and related to the state of New Jersey. If you believe that you have a similar issue or concern and you are in a different state, I strongly suggest that you reach out to a competent attorney in that state and discuss the issues and concerns you may have to determine whether or not the state of the law is the same or is not the same before determining whether to pursue any sort of an action. In New Jersey, for personal injury purposes, the statute of limitation is 2 years from the date the person knew or should have known through reasonable diligence of an injury and the person who caused that injury. Otherwise, they will be foreclosed from seeking damages. If that date is from the date of death, the date of death is the starting point of the 2-year period, because we are going to be talking about death today. A topic that we're going to be talking about today is suicide and the negligence in the failure to prevent suicide. More specifically relating to medical professionals who are treating individuals, at least as it relates to New Jersey, because we're going to talk about a couple different areas there. So suicide is a difficult topic to talk about. It's difficult for people to deal with. And it's just an emotional topic in general, because a person has taken their life essentially, and it's a difficult thing for people to reconcile, for people to understand, and the desire to try and figure out why someone committed suicide or what caused them to commit suicide, or whether they could have been stopped. And that's the particular thing we're going to be talking about today. It comes up a lot because a lot of times we never find out. Kate Spade committed suicide fairly recently, Chester Bennington, Chris Cornell, Robin Williams was an individual who was very well known. I mean, he's Genie, for God's sake. And he's not the type of person that I, as a fan of his, would have ever expected for him to commit suicide. But it just goes to show you that we don't know people. I didn't know him personally. I didn't know what was going through his mind. And, we'll never really know what caused it exactly, although the diagnosis of the early stages of Lewy body dementia likely played some part in that. But it's common for people to want to try and figure out the cause and see if there is someone else to blame. And so the question of whether or not there is a basis to hold someone else responsible for another person committing suicide is an interesting legal case, because primarily you're going to see negligence actions related to that, where an individual on behalf of the estate and the heirs attempts to hold someone or someone's responsible for the suicide in some way. And in New Jersey, I was able to locate a case called Cowan, C-O-W-A-N versus Doering, D-O-E-R-I-N-G. It's a New Jersey Supreme Court case from 1988, where the New Jersey Supreme Court identified a capacity-based standard where the individual's capacity is what controls the extent by which their comparative negligence can be found in terms of their responsibility for suicide when a suit is against the medical professional. In Cohen versus Doering, the individual was a mental health patient who had already attempted that morning to commit suicide unsuccessfully, and then tried again later that afternoon, again unsuccessfully, but the second time she sustained very significant injuries and she sued. Now, at the trial court level, she was found not to be responsible as a result of her lack of capacity, and she was awarded funds. And when it got up to the Supreme Court level, they said that A, the medical professionals knew or should have known that she had suicidal tendencies, especially given the fact that she had attempted to commit suicide the earlier that morning, and B, her placement at that facility was designed specifically to stop her from being able to commit suicide because she had suicidal ideations. And so they also found that as a result of her lack of capacity, they likened her to an infant and upheld, in some respects, an infant standard, which said essentially that she could not be held responsible for her actions. And so that meant that the medical health professionals were in fact responsible, and the jury award was upheld. I also recall, as you may, the tragic instance of Mr. Roy and Miss Carter, where Mr. Roy, who was a young teenager, was found deceased in his vehicle, and that his phone had contained a significant number of text messages from his girlfriend, Miss Carter, essentially inciting him to commit suicide and, chastising him when he was hesitating, and to the point that he ultimately did in fact commit suicide. She was tried and convicted in Massachusetts for encouraging him to end his life, and that was upheld, and she was sentenced to 15 months in jail for involuntary manslaughter. Now that's criminal, not civil, and that dealt with more direct actions through the text messages and the encouragement, whereas the case of Cohen versus Doring dealt with a much less clear connection, in the sense that the medical professionals did not goad her into attempting to commit suicide. It was her own intentions. It was the failure to prevent her that is what caused the medical professionals to be found responsible. Now, New Jersey is not the only state to have dealt with these issues and similar issues in other sorts of avenues. One such avenue is dealing with prisoners and individuals in prison. There's a Supreme Court case from the United States Supreme Court from 1976, which is Estelle versus Gamble, and that held that a custodial agency such as prison may not act with deliberate indifference to an inmate's serious risk of self-harm or suicide. And so that case held that prisons could be held responsible for failing to act upon information that a prisoner was at serious risk of self-harm or suicide. And the line of cases that have occurred after that have specified in much more detail the actual standard that is applied related to that. In addition, in 1975, the Northern District of Georgia, in a case called Snyder versus Hyatt Corporation, found that under the particular circumstances in that case, that a hotel could be held responsible for the suicide of a guest in the hotel. She had been an intoxicated guest. She had checked in with no luggage. She had been found wandering the hallways on the floor that she was checked in at. Her family had contacted the hotel advising of their concerns, and the hotel itself had apparently become a somewhat popular spot for individuals to commit suicide, and so the court found that the hotel had a duty of care that they had failed to uphold towards this individual, which allowed her to commit suicide when they should have stopped her. And so damages were found for the family of the deceased individual. And this is particularly relevant given the recent and extremely unfortunate passing by way of suicide at the Borgata down in Atlantic City of Eric Zaun, who was a professional volleyball player. At this time, it seems to be unclear what exactly caused the suicide, but the question, as in all of these cases, is, you know, what caused him to commit suicide? Could something more have been done? And we're likely never going to know the answers to those questions. It does not appear that the family has taken legal action at this point in time, and they may not have a basis to do so. I'm not involved in the case, and I don't have any particular information other than what has been publicly made available relating to his suicide. But if you, your loved one has attempted suicide or has in fact committed suicide, and you believe that a medical professional or other facility or location should have done more to prevent the actions, you should immediately contact an attorney in the area where you are located to at least discuss whether or not you have a case. If you're located within the state of New Jersey, which is where my office practices, you are welcome to call us. We're happy to see if we can be of any assistance in this tragic and unfortunate time for you. Our contact information will be listed within this video. My name is Tara McGitz. I'm an attorney with the law offices of Drinkwater and Goldstein. And if you have any suggestions or questions that you would like answered, drop us a comment, send us an email, give us a call, and we will try and answer that for you. If you have a topic for a video that you'd like to see, you can send it any of those same ways, and you may see it in a future video. As always, see you next time.